Hello, everyone, and welcome back once again to Immigration Talk Show. I'm your host, Nipasa, and I have another very interesting and insightful session lined up for you. So stay with us. Yes, and before we head on with today's discussion, and I have our guest join us, I have this very important disclaimer to also read out. So, yes, friends, by watching our videos, you agree and understand that the information shared by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. I hope you keep that in mind. And also, welcome once again to Immigration Talk Show, friends. It's going to be very, very interesting because we are going to have another very insightful discussion. And yes, this has been creating actually a lot of uncertainty and concern in the recent months, if we look back as well, border issues or visa delays and sudden changes at US consulates worldwide. So, all of these things are what we're going to discuss today. And, if you've recently also faced some sort of unexpected questioning at the airport, long visa wait times, or are even confused about, shifting policies from CBP or consulates, you're not alone. And you're welcome, very much welcome to ask your questions, to clear your doubts. And you can do so by commenting wherever you're watching or join us on conversation on call. And do that by dialing this number 425-436-6335, and the access code is 988-888. So, yes, without further ado, to help us unfold today's discussion, please help me welcome Attorney Justin Rivera, Senior Immigration Attorney at Wasden Immigration Litigation, based out of Houston, Texas. And Justin always brings a wealth of experience and deep commitment, to helping individuals and companies successfully in immigration maze. But also, it's always great having Justin here with us because his insights are really very helpful. So hi, Justin, once again, and welcome to Immigration Talk Show.
Hey, thanks a lot for having me. It's good to be here.
Yes, same here. So I'm looking forward. I know sometimes we don't have too much of good news to share with all of our audience, but these are important points and we really need to mention. So, yes, today's discussion on the topic trouble at the border, what CBP, visa delays, and consulate changes mean for you. So I think it's only obvious what we can expect, but do highlight some points so that people out there stick with us.
Yeah, I think it's imperative moving forward as we've kind of got we've gotten through the first quarter of the year, right? We're pretty much moving into the mid part of the year, and we're starting to collect data. We're starting to have information that's going to give us an inclination as to what to expect over the next 4 years. And I think that most of that data has led to the conclusion that what you can expect is a more aggressive approach when it comes to immigration in the United States. And that's going to be applied across the board. And that means USCIS will probably be more stringently adjudicating their cases. CBP will be more stringently reviewing people for inspection and admission, and the consulates will be, utilizing the enhanced vetting to more heavily scrutinize applications for visas. And so I think across the board that's already been seen, and it's gonna lead to a need to educate and prepare individuals for all aspects of immigration, not just the filing at USCIS. I think the days where you can just send someone abroad and confidently know that they will come back into the U.S. are gone. I think that that's just how it is. And to just anecdotally mention it, so to give you guys an understanding of kind of what we're dealing with right now, I actually this morning had an individual who got a visa, an H1B visa, issued to them on, I believe it was the 11th. They picked up the visa on the 11th, I believe, at the consulate in Hyderabad. And they went to travel yesterday. And while they were traveling, they were stopped in Qatar and actually told that they could not board their plane because their visa had been canceled. Now, this visa was only issued 6 days ago, and it was approved by the consulate. Between that time, when it was approved and when this individual traveled, the consulate canceled the visa, did not notify the individual why the visa was canceled, and gave the individual no opportunity to respond to an issue or provide additional information. He had no idea whatsoever that this had happened. Now, this is the first inclination of this that I've seen, but according to him, when he was in Qatar, when he was at the airport, he was actually stopped by individuals who basically took him aside and waited until members of the U.S. Embassy actually came. And those individuals told him that he couldn't come in. What was really ludicrous about the whole situation was they could not explain who canceled his visa or why his visa was canceled. There was nothing. There was no paperwork provided. There was nothing communicated at all to this person. He was literally just told, you can't travel into the US on that visa. They turned him around and had him leave. So that's the kind of world we're living in presently. And I think people need to be aware of it and prepared to deal with those issues. Now, this person I truly believe will exist as an outlier. At least that's my hope. But we'll have to kind of wait and see. But I do want to kind of give you that personal story about something we've dealt with very recently that highlights what it's like traveling abroad right now.
That's crazy. I mean, if the person didn't even know why he had to go back, he doesn't know. I mean, I what about the situation now? Even now, there's no real.
So they told him to contact the consulate for an explanation. Now, what's interesting about that is it is very hard to get someone from the consulate to speak with you while your visa is being reviewed. After your visa is approved, it's darn near impossible. You can't just walk into a consulate and say, hey, I have a visa that got canceled. Can someone talk to me? You're not going to get into the consulate without an appointment. And so we are corresponding or attempting to correspond at this time with the consulate to obtain some sort of information. Now, the caveat to all of this, truthfully, is before his visa was issued, he was someone who had one of those SEVIS termination emails.
Mhm.
And at the time, our thought process was, well, that's in relation to his F1 visa. You know, it has no bearing on the H1B. Otherwise, it would have been brought up at the consulate when they were doing his interview. My thought initially is, hey, maybe the officers were wrong. Maybe they thought the F1 being revoked, the F1 visa, somehow played into the H1B, also somehow being revoked as well. That's possible, but it doesn't make sense. Like there's not a justification for that. Like it's not logical to say that, oh, that F1 student visa, which by the way was actually withdrawn at the port of entry because of this case. I won't go into the further specifics of it, but it had actually already been withdrawn, this visa. So when the SEVIS termination happened, it actually canceled or revoked a withdrawn visa, which makes even less sense. All that is to say, we don't have a justification. We're trying to get one from the consulate. I will let you guys know, like next time I'm on, what the conclusion of that is. But I think at the end of the day, the problem is you've just inconvenienced this person. Like this person now has to very likely go to another visa interview, hopefully get issued a visa because they already had an issue getting it given to them the first time. and then
True.
travel again and hope that they can come into the United States. And by the way, just to put a button on the end of this individual isn't somebody who works at, a 7-employee consulting company or one of these employers that the Trump administration clearly is targeting in regards to H-1Bs. This person works for a university. They work for a prominent university. And the fact that that person is now incapable of returning to their employer at that university because of this mix-up, it's ridiculous. But I think it is telling in that we'll see a lot of this kind of stuff happening over the next couple of years.
Sure, sure. I mean, we just have to be ready for anything and everything, friends, and also be prepared. I think the best way possible with all the documentation, right? But still, we don't know what can happen. Let's just hope that we are lucky and pray hard. I think
Mhm.
that's all we can say for now. But let's come to our discussion for today's topic, friends. And yes, I do have questions. And quickly, I'll just say hello to Yuri. Hi, Yuri. Thank you for joining us here on YouTube. We are going to take up your question very soon, but stay with us for now. So, Justin, we've really heard a lot about these secondary inspections lately, and if you can explain what they are and why travelers are increasingly being flagged for them.
So, yeah, I think secondary inspection. So, just to explain what secondary inspection is, when you come into the United States, you go through CBP, right? CBP has the ability, the authority to uh, inspect you and ultimately grant you admittance to the United States. Now, most people's inspections are brief. It's a couple questions, maybe none, and then you're flagged in. Look at the docs, say hi, where are you going, where are you working. That's it. You come in. Others, typically people who have a flag in their immigration record. Maybe something like they've worked with an employer that's previously been flagged, or they work in a contractor situation where they work for an end client. Um, Maybe someone who has been in the U.S. for a long time on one type of visa and then has moved to another visa and is then coming in. It's a litany of justifications that are now being utilized. But by and far across the board, when secondary is invoked, it's because there is allegedly some information that is displayed on CBP's data hub that leads them to believe that they can ask additional questions. Now, I think before the administration change, that CBP secondary inspection was something that was more readily available for kind of outlier situations, circumstances where maybe there was a clear flag that was placed by FDNS, who is USCIS's fraud detection agency, in relation to a case, and the person's taken into secondary in question for that. Now we're seeing it used with a much broader scope, and secondary inspection has been utilized now on, visa holders, legal permanent residents, and there's even been occurrences with U.S. citizens being taken into secondary inspection, which is really interesting because a U.S. citizen can't be denied entry to the United States, but they're still taking them into secondary, which is, it's odd. But once you're in secondary inspection, you are there for as long as they tell you you are there. Meaning,
Mhm.
if they want to hold you for 2 hours, they can. If they want to hold you for 8 hours, they can. And during that time, they have the ability to review any of the electronic devices that are on your person and any of the information that you have on hand, physical copy of a resume or something like that.
Mhm.
So I think before, most of the time when you had someone traveling into the US, the thought process was you got your visa. Let's say you're on an H1B. You got your visa, you got your approval notice, you got,
Mhm.
your an employment verification letter saying like, we need this person to work in the US. You're good to go. That was before. I think nowadays people need to be prepared for the thought of CBP having deferred inspection occurrences with way more regularity. And unfortunately, we've heard about certain ports of entry specifically that have more aggressive CBP officers than others. I specifically would highlight Atlanta, the airport in Atlanta. who we've gotten reports of officers doing really questionable activities. Anyway, once you're back there with CBP, they have access to everything you have on your person, and they're gonna, ask you any questions related to anything in relation to your immigration record. That could be, previous H1B, previous F1, your current H4. Anything is on the table. Now, I would be kind enough to CBP to say that before the administration change, the only people they were really hounding on were people that they thought that they already had issues for fraud, like fraud finding issues, and they were basically just trying to get the person to admit to the commission of fraud or misrepresentation so that they can put them in expedited removal. Nowadays, I think that they are more aggressively employing intimidation tactics with the end goal of trying to secure more expedited removal orders to make their immigration records look better. That's my personal opinion. Now, the reason for that is to go around and deport people that are in the country illegally, you have to find them. And it may not be that easy to actually find people that are actively hiding in the United States. Someone that comes in through CBP has to be inspected and admitted. They avail themselves to the officers. So if someone's right in front of them and they think that they have a way to get that person removed or cancel that person's visas, I kind of think that's the way they're going to behave presently. And I think we've seen that play out with a unfortunately high level of frequency over the past few months. And that's really it. I mean, that's kind of all of it in a nutshell. It's unfortunate, it's disheartening, but I think it speaks to the anti-immigration desires of the present administration.
Right, and it's happening. So, friends, whatever you've been hearing is true. And I know this is really bringing up a lot of different mixed emotions, rather. People who had dreams to come to America, they're now rethinking rather, or maybe routing out to different countries as well. That's what we hear. I mean, I'm just saying it from the news. So, yes, that's there. But anyway, yes, friends, traveling is still on, but do make sure of your plans and see that, yeah, I think all your documents they need to be on point for sure. And now let's go on to my next question. What specific categories of travelers, whether students, workers, or visitors, should be most concerned about being questioned by CBP upon entry?
So I think that students engaged in OPT and STEM OPT, I think, should be very cautious over the next few years with travel in and out of the United States. Um, I don't think it's any secret that Stephen Miller, the proponent and architect of the Trump administration's immigration policies, Stephen Miller does not like that the F1 students have work authorization. They, take the stance that that work authorization is unnecessary, and that after individuals complete their studies, they should either, transition to another visa or depart the United States. Basically, once you're done studying, you should go. You should leave. It's ridiculous, obviously, because the United States benefits from highly educated individuals remaining here and working, and usually a lot of those people transition to an H1B. But those individuals, I think, they're definitely being targeted at a significant rate. H1B holders who work for traditional, bigger organizations, like really, your Metas, your Googles, all that stuff. Those people seem okay. The people who I think are seeing the biggest pushback are people who work in contractor situations, people who work at third-party client locations. I think those individuals have been getting pulled aside in secondary more. There is a really big. I've just seen this from several cases. There has to have been with CBP some sort of internal memo or something issued about verifying somebody's placement when they're working at a third-party location. And that's either, through them producing a client letter or producing the name and, the contact information of a person that can verify their placement at the location. I think those are the individuals that I've seen with the biggest level of pushback. And that all being said, there's also been individuals who've come in on B2 and had their visas canceled. I think there was a very big public hubbub recently about some European kids who were trying to go on vacation in Hawaii who got their visas canceled because they admitted that while they were in the US on B2, they might actually do some work for their client that was, in Europe. And they said, that's not the purpose of the B2 visa. Your visa's canceled. So they will look at everything, everyone across the gamut. But in terms of the general people that I think have the biggest risk in travel right now, I think it's the F1 students that are here solely subject to work authorization, and the H1B holders at contractor companies.
Right. Well, thank you so much, Justin, for that detailed explanation. And folks out there, thank you for joining us. Hi, Jay Bhatt. We are going to take up your question very soon. And please feel free to comment, whatever questions you have. We are going to take them very soon. Also, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Also, check us out not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. Follow us, subscribe to us, and stay connected. So, yes, I think let's go on to the next question that I have for you, Justin, is why do some immigration experts suggest that returning to the US should be treated like attending another visa interview?
Because it has the potential to be, honestly. When you go to the consulate for your visa interview, um, generally, the officer's trying to affirm at the consulate that the statements and facts within the petition are accurate and correct, and that the individual will utilize the visa within the parameters of what the visa is for. Perfect example that would be, if you're applying for an H4 and you go, what are you going to do while you're on the H4? And you say, oh, I'm going to go, in the United States and I'm going to live with my spouse. Are you going to work? And you say, yeah, I'm going to work. Well, you have to have an EAD to work. So unless there's some level of clarity there, saying, oh, I'm going to work once I have an approved EAD or I have an approved EAD, you might be operating outside the confines of what the visa allows, which is a problem. So that traditionally was something that you dealt with at the consulate. And at the consulate, they have the opportunity to review any of the information that you submitted in the DS-160. The DS-160 can ask if you've ever overstayed your visa. Have you ever been violated your status? Have you ever had a visa canceled? So all of those things are grounds for scrutiny. Before the new administration came in, that was all done at the consulate. And then once you came in with CBP, and you would hear of the very extreme outlier individual situations where CBP deferred inspection led to an expedited removal. And it would almost always be a dead to right situation where, FDNS has basically clearly established some sort of fraudulent activity in relation to the company or the individual. They come in, they put them in secondary, they procure a document, or they get an omission that, oh yeah, I did something that was fraudulent. You go through expedited removal. Now, because they have really augmented the purpose of secondary inspection to encompass previously, unthought of scenarios or issues, now you have secondary inspection being used almost like an opportunity to do another visa interview. It's another opportunity to, say, use an H1B, for example, go through the petition, but not only the petition, the individual's immigration history in the country as well. And that's something that I think people need to realize as the kind of new reality. Now, the difference between the consulate and CBP is obviously when you go to the consulate, most of the time your interview's 10, 15 minutes. Outlier situations, they might take you into another room to ask you a couple additional questions. But by and large, it's a quick thing. It's a fast process because the consular officer has, 40 other people to see today, so she's just trying to move people through. Secondary inspection is not like that. Secondary inspection is intentionally slow. It is an intentionally drawn out process. The reason for that is the CBP officers are basically trained to utilize making an individual uncomfortable, with the underlying purpose being that you're going to want to avoid the situation you're in. And eventually, if you're worn down over a certain amount of time, you're just going to give up. And you're just going to say, all right, whatever, say whatever you need to say to get out of the circumstance. And that difference is important because it really highlights the fact that by and large, the consular officer, they're going to be looking at you and saying, okay, I'm going to try to adjudicate this fairly. We hope. CBP, just based on what I've listened to over the past couple months, I am not giving that kind of good faith to anymore, especially in certain locations. I think the desire is more actively to cancel visas and have people removed. And that's why I think now the consulate obviously getting your visa is important, but if you have any of these factors that have been highlighted so far, a previous overstay, a violation of status, a problematic employer in your work history, anything, a speed bump, a ticket, an interaction with the police, any of that needs to be prepared for, because when you come through CBP, they can, and in this current day, very likely will raise it as an issue.
Okay. Well, there you go, friends. I hope you're taking notes. And thank you so much, Justin, for that detailed explanation. So, we should take up some of our questions from our audience as they've been waiting. And let's go ahead and take up Yuri's. Yuri is asking, if my visa is delayed because of changes in consulate policy or new procedures, do I have to recourse? Can I appeal or request expedited processing to mitigate the impact on my situation?
So you can request an expedite of your visa appointment under certain circumstances, and those circumstances are country specific. Generally speaking, an expedite request is for something like an extreme humanitarian justification. I think off the top of my head, in Canada, you can expedite for a humanitarian reason or for a work related reason. Like an example being, I am on an H1B, my employer needs me in the US by, uh, June 1st. And if I'm not there by June 1st, I'm going to lose the work opportunity. I'm probably going to lose my job. So there are ways to expedite the appointment. Now, once the visa interview has occurred, if you're placed in administrative processing or your passport is taken and they're saying, we're going to issue the visa, if your case is being held up, there are very limited things that you can do. If you're in a 221G, you turn over the documents and information that they ask for, and you're placed in the queue to wait. Um, Sometimes you can move things along if you're able to show that you have urgent travel. Like for example, I had a client once who the consulate had their passports for, I think we'd been going on 10 days, 10 to 11 days, and they had tickets showing that they needed to travel because it was almost New Year's and they were trying to get back to the US. And so I sent the tickets in to the consulate. I said, look, can we do this for them? Like, we need to move them along. And they did issue the visas the next day. They gave them back passports with the visas and everything, and they came in. Outside of those kind of certain, outside of those avenues, it's generally hard to get your case expedited. So yeah, I think for the most part, it'd be, proving imminent travel, the need for imminent travel. And then you have to have proof. You have to have actual proof, meaning, airline tickets showing that you're going to be traveling. And consulates will typically be sympathetic to that. Outside of that, there's really not much more you can do.
Okay. All right. Thank you so much, Justin. And Yuri, I hope you got your answer. Thank you for joining us. Don't forget to subscribe, friends. Our handle is at Immigration Talk Show. Check us out, and also check us out not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. All right, so now let's take up Jay's question. Jay is asking, what if CBP holds my documents at the border for more than the standard amount of time? Should I be concerned, and how can I get the legal assistance to resolve this quickly?
So there's not a there's not really a standard amount of time in terms of secondary inspection. And remember, this goes back to the idea of a delay tactic. There is a benefit to the officers in making you uncomfortable and having you wait for long periods of time in between rounds of questioning. makes anybody irritable or, scared. If your devices are seized by CBP, they have two things they can do. They can do a quick search, which is where they basically have you unlock your device and they look through the device. Which, that's, they're going to kind of maybe go through your texts, look at your emails, something, WhatsApp, whatever. So that's kind of usually the route that's gone when it's like you're put in secondary, but they don't really have anything concrete against you to actually have a finding placed against you that'll get your visas canceled and get you revoked. The other method is an enhanced search, and that's where they basically have technology that they can use to look through your devices for specific documents or information. I don't have a perfect understanding of the way the system works, but my inclination and what I've gleaned from others is that they basically will look for certain words, because they already have a preconceived notion, and then they're just looking for what they want to get the proof, the definitive proof. So one thing that they're big on is the idea that, someone paid for an H1B employment. And so what does that mean? That means you paid the H1B employer in return for them to sponsor your visa, or you paid for the filing fees to USCIS or the attorney fees. So they'll look for, paid H1B, paid attorney, paid job, and they will look through your devices to see if there's anything that comes up that reflects that information. What they're looking for is, the dead in the water, the silver bullet. They're looking for, is there a text that says I'm paying this in return for this, or is there an email that says something like that? And then can they use that document to work backwards against you and say, hey, we have this and you said it, like you clearly said it. So you did this, right? And that's what they'll use to cancel your visa and put you in expedited removal. So those are the different ways in which they do the search. Now, either way they do it, they're not going to do it quickly. They're going to be very slow. I think we're looking nowadays at a traditional secondary inspection being 2 hours long. And the purpose of that, again, is to make you uncomfortable. But I think it's very important to remind people that in order to have your visa revoked, during a CBP inspection, have your visa canceled, it requires you to either make an affirmative statement to them that you have done X, whatever offense it is that makes you inadmissible, or have them procure evidence that establishes that you did X, which leads to you being inadmissible. Absent of those factors, they have to grant you admission to the United States. An example that I will give is I had someone who went through, I believe it was Logan Airport in Boston, Massachusetts. They went through Logan Airport and they were in secondary inspection for 5 hours. And they were there for 5 hours. They said they spoke to 3 different officers and 1 supervisor. And at the end of the day, even though they were told repeatedly, we know you did this, we know you committed visa fraud, like you just confess and everything will be okay. He said, I stuck to my guns. I had talked to you, me, the attorney beforehand, and I knew what was true and what wasn't true. And I just, kept reiterating the truth of the matter, and they had to let him in. And he ended up being admitted to the United States. Now, have I subsequently told him, hey, maybe don't travel for like 3 years? Yeah, I've absolutely told him that. But I say all of this to tell you that there isn't traditionally a way for them to do these kinds of things without justification. There has to be a basis or a rationale to the decision making that's made. So while it is frustrating that there's this increase in secondary inspection, I think as long as an individual has been prepared thoroughly to understand what the process looks like and what to say and what not to say, not because not saying it is withholding the truth, but because you're not saying something because you're not trying to avail yourself to information that could lead to a problem. I think that's all important. I think that's why it's really important to either, speak with the employer before you're traveling or speak with an attorney, just so you have that opportunity to be prepared in the event that this happens. And so I hope I hope that answered your question competently. Um, yeah, and how can I get legal assistance to resolve this quickly? It's a good question, and that's the real big issue with going through CBP. You're not entitled to legal representation because you haven't been admitted to the United States. So, yes, you can present evidence of representation by an attorney, but then you're at the discretion of the CBP officer whether to invite that, whether to allow that. And I would say by and large, they're not going to do that because they don't want to get an attorney involved because they know that once the attorney comes in, it shuts down a lot of the intimidation factors that they are dependent on to get the result that they want.
Right. Well, there you go, Jay, and thank you so much for this very interesting question. Thank you, Justin, for taking that up, really. And now I think we should take up generics as well. Hi, generic. I'm sure that's not your name, but I wish I knew your name. Anyway, so for H1B holders already in the US who are petitioning for a second term, 3 more years, that is there anything that they should be concerned about?
Yeah, I mean, not in terms of travel, obviously, generally speaking, but if you're just talking about filing a USCIS extension, yeah, I think you should be concerned with an increased rate of RFEs, just to be blunt. You're probably looking at a significantly higher risk than during your original petition's approval of getting a request for evidence, probably for specialty occupation, if not for something else. But yeah, I think really that's it. I mean, you're just probably going to be looking at more RFEs. The idea that there was going to be kind of like a big surge in site visits for H1B holders hasn't really occurred that much. I don't know if it's my honest belief is that they're waiting until after quota, after H1B quota, so after the end of June. I think from July to September, the end of that, I think that's where you're going to see a bunch of H1B site visits occurring, because because I think what's going to happen is they're going to approve cases and then try to subsequently invalidate them, like basically get cases denied for people, like basically once the person transitions to H1B, issue a notice of intent to revoke or something like that. That's just theory. That may or may not be true. But for people that are looking at second extensions, I think that you're just yeah, you're probably going to have a higher rate of a specialty occupation RFE. Now, if it's an H1B where it's the same petition, it's a continuation of employment, without change. There's likely going to be less scrutiny on those. But I think that where there are, extensions with change or amendment plus extensions, I do think that there's going to be a higher level of scrutiny on those cases.
Okay. Thank you, Justin, for highlighting that, and thank you for that very interesting question as well, generic. I hope folks out there are taking points because these are very important points that we have been discussing. And also, Justin, what do you have to say about the latest? That they are asking for biometrics as well for H1B applicants, and that is also apart from address changes, which you need to also update to the USCIS.
Well, yeah, I mean, biometrics are one thing, but as just speaking personally, the AR11 stuff, like we people need to be careful with the AR11 stuff because um, there, I think I saw an F1 RFE that actually just came into our firm a couple of days ago, where the person was filing a change of status, and they're basically saying that they never updated their address where they were living, and that their failure to do so was a violation. So that's interesting, but that is to say, I think it's imperative to make sure that you're updating your information. You can't leave any cracks at this point. There can't be
Right.
anything that's left out there that gives rise to the possibility that USCIS can try to claim you were violating status or seek to revoke your visa.
Right. Thank you so much, Justin, for telling us about that also. And now, what would you like to tell us? What are the key documents that travelers should carry to be prepared for unexpected questioning also or document requests at the airport?
So Generally speaking, if you're an H1B holder, I think at this point it should be routine to enter with um, your your petition. You should have your H1B petition. I would have an employer letter that says that you're currently employed and they have continued need of the individual. You obviously need your a copy of the approval notice and the visa and all that. You need all that to get in. But the other thing to remember is when you're coming in now, you need to make sure you're aware of the fact that what you have on your person is subject to search. So anything you bring in, particularly that's an electronic, is something that can be looked at. So do you make the decision then to travel without your laptop, and just travel with your phone? Do you make the decision to just travel with your work phone and leave and bring your personal phone in or ship it into the United States ahead of time? These are all factors that I think people need to consider that they would never have thought they needed to consider before. So while it is important to carry certain items, I think it's almost equally as important, if not more so important, to not carry certain items. I've been pretty much telling everybody across the board that I don't think it's smart to travel with your computer anymore. If you do travel with it and you're coming into the U.S., you should ship it in. That way, it's not physically on your person, and that's really across the board. I don't even care if like you were the most squeaky clean person who's never had any immigration record problems. I still would generally give that as a recommendation. So yeah, I mean, really, in conclusion, it's just you need everything that establishes that you're coming in for the intended purpose of the visa. But I also think stuff that's not going to help with that might be stuff you decide not to travel with.
Okay. Interesting points. Thank you so much, Justin, for taking that up. And now, also, if you could tell us, what are some common mistakes that travelers make during CBP inspections that can actually lead to delays or even worse, um, especially denied at entry?
I think people need to be aware that you have to actually stop and think about the things that you're saying, as particularly to the initial inspection officer. And what I mean by that is this: I had a case that I worked on a couple months ago where essentially the person was coming in and they were being asked questions like, like, how did you get this job? How did you get a job with this employer? And he was like, oh, he said something along the lines of like, oh, I was working for a company on F1, and they told me, if I got selected, if my case was selected, they'd file for me, and then I would work for them. But when I started working for them, they would get a percentage of the purchase order. And the officers was immediately like, somehow inferred from that statement, oh, this guy paid for his H1B. And because he's paid for his H1B, we can cancel his visa and put him as expedited removal. He went into secondary inspection where basically no matter what he said, no matter how hard he tried to explain that what he was talking about was the purchase order and how there's a contract between, employer, vendor, and end client, and there's a purchase order, and that the employer takes a portion of the purchase order as payment. That's what he was talking about. In no way was he talking about paying the company for his H1B or the company garnishing his wages in return for them filing his H1B. It didn't matter what he said. They had already formed this conclusion based off of what he thought was a really like innocuous statement during that initial questioning that they then worked backwards from to get to the point where he ended up being removed. He ended up undergoing expedited removal. So that's what I mean by you have to be thorough with your question, with your answers, because you need to say what needs to be answered and nothing more. If you're asked by a CBP officer when you're coming in, and you're coming in and they say, hey, where are you gonna be going? You should be answering, I'm gonna be going to my work or to my house, or I'm gonna be going to fulfill the obligations of my visa. What you shouldn't be saying is something like, oh, I'm going to go do XYZ, and then I'm going to go on the coast, or I'm going to go over here and do this, or I'm going to go visit my family and friends for a couple days. All that stuff is fine. But when you start word vomiting to the officer, then the officer's looking at you thinking, well, this person seems like they're nervous or there's something wrong. They're behaving in a way that's questionable. we should probably get them put in secondary and see what we can get out of them. So I would say just be prepared to answer the questions purely within the prism of what's being asked. Don't offer up any more information than what's being requested of you, and try to be calm during the situation. I think most people and most times you're going to be okay. But just weirdly, because of the world we live in, we do need to make sure that we are prepared. And that's why I've told pretty much anyone that I do consultations with now about travel, I want you to prepare as if you know you're going to secondary inspection, because that
Yeah.
way, well, but you're ready and collected during the situation.
Right. 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 So thank you so much, Justin. I think we just missed the last line. If you can just
Something.
repeat.
Yeah, it's the weather. Just in conclusion, I would just say prep. Prep to
As
travel
if there's
back
going
into
to be
the U.S.
secondary
as if
inspection
you're going to
again.
be in secondary. Exactly. Yeah. Thank you.
All right. All right. So there you go, friends. I think, yes, it's always good to be best prepared and most prepared, but also be prepared for the worst. Have a plan B just in case, so that you're not that heartbroken at least, or you know what to do even if something bad, I mean, the worst case scenario happens. Anyway, yes, I think now, Justin, we'll just take up some of our Facebook questions as well before we leave. So, Control, if you can display them, please. Um, so, yes. If you can zoom in a little bit. Okay, this is Alice Anderson. Hey, I've been managing a business that serves US clients remotely for a while, but we never formally set up a US entity. With all the recent tariff issues, the market's been quite unstable and it's impacted our operations. Ironically, that shut slowdown gave us the space to explore the L1A route and consider opening a US office. But since things are slow right now, we don't have active contracts in the US. So we're not sure if that would make the visa harder to get. Do you think it's still worth applying at this stage, or should we wait until the market stabilizes a bit?
So a new Office L1A it is an actionable route, but it is very very heavily scrutinized. The new Office L1A, it's tough because you basically have to show that you're coming in to establish this business. What is the plan, what is the model, what are you going to be doing, what is the connective tissue with the foreign entity, how is everything going to be accomplished, and you're basically asking USCIS to either say, yeah, I buy this, or they're going to say, no, I don't really think that's what you're doing, you're just kind of trying to get a visa to come into the United States. And it makes it very hard. We even at my old firm, we would typically discourage new Office L1As, even for individuals that qualified. So in the era of Trump, I think that you are looking at a difficult situation. The L1A, by its very nature, it's document intensive. It's very heavy. You have to supply a lot of information, and then when you add into that the fact that you now have to establish that you're opening a new office, it's going to make it more difficult. Do I think you can do it? Yes. Do I think that it's going to be harder to do now than it was even 6 months ago? Absolutely. But it is an option, but you have to have really strong documents. I mean, you really have to have everything ironed out to where you clearly show what the model is going to be, what's the capital that's invested, who's going to be doing what with that company, what is your anticipated hiring looking like, how are you setting things up for that organization and how quickly it's going to grow, and then go forward from there. But yeah, I mean, I think it's possible. If that's something you'd actually want to discuss in more detail, I would actually recommend scheduling a consultation, and then we could take it up in more detail.
Absolutely. And there you go. You should definitely consult with Attorney Justin Rivera, and you can go check out Wasden Immigration Litigation on LinkedIn as well. You can find Attorney Justin Rivera. Thank you so much, Alice, for that question. Those questions, rather, the situation that you're going through. And now let's take up this next one. This is from anonymous member. We are currently in the US on L1 visas that expire at the end of the year. I started a delivery business last year and I'm considering changing to an E2 visa. I'm planning to purchase a vehicle and rent a commercial space for a year. Is it mandatory to hire an employee immediately for the E2 visa application in this situation? And what are the advantages and disadvantages of pursuing an E2 visa for my delivery business? Will it be worth having a vehicle and business place? I would really appreciate your thoughts and suggestions.
Yeah, so that's an interesting question, and I've that's funny that this happened because I actually had someone else recently talk to me about an E2, and they were looking at E2 versus L1. I want to take a step back and tell you this immediately. If you're an L1 and you're in the US working subject to an L1, like let's I assume it's an L1A, you need to be looking at the L1A to EB1C route for a green card. That's I really think the pipeline that you should be trying to explore much more so than I would worry about moving over to an E2 visa. Is it possible for you to move over to an E2 visa? Yes. There's a lot of planning that needs to go into that. And I think that it's going to be difficult for you to do transitioning over from an L1. Is it mandatory to hire an employee after the E2 visa? I mean, I think it's position specific, but the advantages of the E2 are, it's obvious that you can have your own business and that's great. But when you have an L1, the L1 is kind of not the gold card, because I don't want to use a Trump term, but it is like the higher tier standard of work visa. I mean, yeah, the O1 is slightly above it, but the L1 is really great because it allows your opportunity. I mean, it allows you, if it's an A, to transition to that EB1C, which is one of the easiest green card pipelines there is. And so, yeah, I would need to look at your case more specifically, but it's weird. This must be something that is like circulating right now on the internet. There, it has to be this idea of going from L1 to E2, because this is the second or third time this has been brought up to me. I would look at the specifics of your case, but barring a significant change in my current opinion of the E2, I think being on an L1 is the better route 9 times out of 10.
That up, and thank you, Justin, for taking that up. And now let's go on to this next one. This is also from another anonymous member. Control, if you can please display that, please. Oh, sorry, not anonymous. This is. Could you please zoom in a little bit?
This was written by a mouse.
Masahi. Hello, all. I filed my I 140 and concurrently my wife's I 485, I 131, and I 765 all at the same time, putting them together in one packet. My I 140 was just recently approved. Are my wife's I 485 processed together or are they processed separately? My I-765 was also approved, and USCIS sent me my EAD card, but my wife's one hasn't been here yet. So, looking at my USCIS account page, estimated processing time of the I-765 in 38 months. It's stupidly long, it says. So, she's wondering whether their cases are going to be reviewed and processed separately, even though she is his dependent.
So they typically run them together, on average. Um, yeah, I mean, typically they should be run together. Your EAD being approved though, and your wife's not being approved is not entirely uncommon, but it can happen. When a dependent's petition gets split off from the primary, it typically, yeah, usually is because there is an issue related to that person's status or previous time in the United States. So, for example, like let's say hypothetically, you and your wife, you've been in the United States, you're filing to adjust status, and before that, your wife was in F1 status, and there was a violation of status for whatever reason. They could split it off and issue an RFE specifically on your wife's application, and that's completely unrelated to yours. So yeah, if it's been split off, that's definitely a possibility. I know that's not probably not the answer that you want, but it's very likely what's occurring. The other thing that could be occurring is just that USCIS is stupid, which they definitely are, and they adjudicated your 765 and just forgot to do hers, which could also happen as well. You can usually use the EMMA tool to reach out to USCIS to get an update. If you've already done that, you can try calling them to get information. They weren't helpful in the last administration. I've got to imagine they're even worse now. But those are really kind of the only avenues you have to explore because you can't really proactively submit anything because you don't know what the issue is. So those are really your only options.
Thank you, Justin. Thank you. And I think we just have a couple more and we'll quickly take them up. So, control, if you can just display that, please. So, anyway, I'll go ahead and take up CL visa. I mean, I'm selected this year in lottery. Uh, So, okay, let's take this one first. Sasi Raj is asking, hi, are people who got into H1B lottery this April this year going to expect calls from software companies here in the US? How will be the IT industry market for new H1B visa holders this October 2025? Can new H1B visa holders expect interview calls?
I don't know what that means. I'm a little confused by what the question there is. If you're picked in the lottery, it's because you had an employer that agreed to sponsor you for an H1B, and that sponsorship is based on the fact that at the time of filing, you have a job offer, a bona fide job offer,
Already.
an actual opportunity. Yeah. So if you get to the stage where your H1B is selected and you're taking interviews, that doesn't make sense. You know, your employer is responsible for having that work lined up. And if they don't have that work lined up, then that's a problem. Now, alternatively, if I want to paint this in as nice a light as possible, maybe that question is trying to say, you know, I got selected for an H1B with ABC Consulting Inc. And ABC Consulting Inc. is trying to make sure that I have a long-term project to be placed on when my H1B is filed. And if that is the case, and you're saying what's the IT market going to look like, I don't know. I think generally the economy's not looking great right now. I'm just going to be, blunt with you. That I'm just being honest with you. The markets are doing what the markets are doing because of volatility, and there has been a lot of talk in big industries about hiring freezes.
Yeah.
And anytime hiring freezes become the commonplace, that they're not adding new employees, especially to bigger companies, that's really the first cost cutting measure. You're saying, okay, we're going to stop on the expansion and deal with what we have. If you continue down a road where profitability is an issue, the next part becomes reduction. And so, yeah, I think that, look, things could definitely change immediately. We've already seen how the president behaves. Tomorrow he can cancel all the tariffs. Who knows? It's we're really living on the coattails of the whims of a person who makes decisions based on mood. So the tariffs could end up being gone, or they could raise taxes on everybody. We really don't know. But what I can say for now is, if you have a selected H1B and you have a project that's a confirmed project, you need to file. Like, you need to file and you need to get that H1B in and get it approved before all these companies start pulling back on their need for contractors and third party placement individuals.
Mhm. Mhm. Thank you, Justin. Thank you for taking that up. And now this last question of the day is from Sia. I'm selected this year in lottery. My B1 B2 visa was rejected in 2017. Can it affect my H1B visa interview? Can I mention in DS 160 that my B1 B2 was rejected before? Please advise.
Yeah, I think a question in the DS 160 is if you've ever been denied a visa or had a visa revoked. So it's something you have to disclose, because if you don't disclose it, you're making a material misrepresentation and you're not going to
Yeah.
get your visa and you're going to have a fraud finding placed in your record. So, yeah, you have to disclose it. I think that as long as the rejection or refusal of the visa isn't tied to something that makes you permanently inadmissible, it's not going to be an issue. So, yes, you have to disclose it, provide an explanation, justify what happened, and you're fine. 95% of B2s are 214B refusals, which means that you haven't convinced the officer that you're going to either visit the US temporarily, that you have you have non-immigrant intent versus immigrant intent, or that you haven't shown you have strong enough ties to your home country, which would lead them to believe that you're going to abscond and stay in the US.
Right.
214Bs can even just generally be issued as like, I don't like the cut of your jib. Like, I don't like your vibe. And as a result, I'm issuing a 214B. So if that's the case, it's super common. It's not going to be a problem for you. If it was due to you blatantly making a misrepresentation, then yes, it's a problem. But I would say 9 times out of 10, no, it's going to be fine, and admit it. The last thing I'd give you guys before we get off the call: don't try to hide stuff from consulates. You don't know what information they do and don't already have access to. The government has a system that connects CBP to DHS. They share information. Assume that if one entity has it, the other entity has it. The worst thing you can do is lie and then get caught lying at the consulate, because then you will get a permanent ban to the United States. So, yes, in conclusion, yes, bring it up.
Yes. There you go. Thank you so much, Justin, for taking all of these questions from our audience and from me as well, so patiently, and for all the information you shared. I loved this conversation we had today. So much good information and important information from your end. So, thank you. And maybe if you have any end notes or tips or anything you want to say to everybody watching us right now before we leave.
No, I'm good. I got to get a drink of water. I've been talking for like an hour straight. It was a pleasure having me on. Thank you very much.
But thank you so much, Justin. Yes. Have a great day ahead and see you soon.
Yeah, you too. Bye.
Bye bye. Folks out there, if you do need to have a one-on-one consultation with attorney Justin Rivera, you can also call him up, and his number is 844-592-7366. You can also email him at, sorry, I'll repeat the correct phone number. It's 844-592-7336. And the email address where you can get in touch with attorney Justin Rivera is support@wasden.law, and go visit www.wasden.law to get to know more about Wasden immigration litigation. And also don't forget to check them out on LinkedIn. They are Wasden Immigration Litigation. Also, friends, if you have questions that you would like to address, and which I could take up in our next webinar to the attorneys, you can also contact me. My phone number is 408-335-6444. This is also my WhatsApp number. And you can also email me at neepadstaffingly.com. So thank you once again, everyone, for joining us. If you haven't as yet subscribed, subscribe now. Our handle is at Immigration Talk Show. Also, share this handle with your friends and family who could benefit most with all our U.S. immigration content, the latest ones, especially, because we don't miss out on updating you as soon as possible. So check us out and share this handle, like, share, and subscribe, basically. So thank you once again, everyone, and see you soon. So stay tuned to Immigration Talk Show.